Good morning, everyone. I'm Judge Jackie Powell, and we are in the first appearance court. We're about to start that docket. It is fairly large this morning. So today, I want to say, like I say every morning, today is not your trial date. Today is a day that we are going to talk about probable cause, and then we're going to talk about release conditions. Everything in this courtroom is being recorded, so anything that you say on the record can be used against you at a later time. We have attorneys from the Public Defender's Office. We have in the courtroom, Mr. Brian Reedy, and over at the main jail, we have Mr. Attorney Hector Romero. For those of you who are represented by the Public Defender's Office, please make sure you speak with your attorneys before speaking on the record. Also, if you have a private attorney, they come to the courtroom and they'll be able to speak on your behalf as well. I also have the attorney from the State Attorney's Office, confinement status and pretrial supervision in case anyone is to be released on those conditions. So I have read these probable cause affidavits, and we will go through if your attorneys have arguments to be made. What do we have? Oh, who needs a Spanish interpreter?
Actually, the first case on the docket, Your Honor, Norma Caldera. She's in North Broward.
Okay. Is there anyone else who needs a Spanish interpreter?
There's another person at North Broward as well.
Mr. Gomez. Nobody here requires a Spanish interpreter at this time. I don't know if, like, further on in the docket.
Gomez at North Broward?
Page 12, Mr. Gomez, Norgera, Eugenio, Bernardo.
Okay.
Yeah, something.
All right. Just tell us what the last name is.
Gomez.
Gomez.
You want this? You want Miss Cardero first? She's the first one on your docket.
Yes, and then we're going to need, is it Mr. Gomez? Because the Spanish interpreter is here.
Miss Cardera. Cardera, come on out here.
All right, while we're waiting, do you want to raise your right hand? You swear affirm to translate from Spanish to English and English to Spanish?
I do. Espan Rojas.
Thank you. All right. All right. Good morning, Ms. Caldera.
Buenos días, señora Caldera.
Buenos días.
Good morning.
Ms. Caldera, you are before the court today for one count of domestic battery by strangulation.
Señora Caldera, usted está ante este tribunal hoy porque está acusada de un cargo de lesiones domésticas mediante estrangulación.
The court does find probable cause.
Consideramos que existen indicios probables.
And I will hear from the parties in regards to bond.
Y ahora voy a escuchar a las partes en lo que se refiere a la fianza.
Okay.
Your Honor, the state would be requesting a $7,500 bond and no victim contact.
Su señoría, la fiscalía solicita que se le imponga una fianza de $7,500 y que se le prohíba tener contacto con la supuesta víctima.
Está bien.
Okay.
Based on the allegations of strangulation.
Dadas las acusaciones de estrangulación.
And it would appear that there was a witness to the strangulation that occurred outside the residence.
Y al parecer hay un testigo que presenció el intento de estrangulación afuera del domicilio.
Nothing further, Judge.
Nada más de parte de la fiscalía, señor juez.
And does Ms. Caldera have any priors?
No, Judge.
¿Tiene antecedentes la señora Caldera? No, señora juez.
Okay.
Well, Judge, I was not able to speak with Ms. Caldera because my Spanish really isn't very good.
Señora juez, yo no pude hablar con la señora Caldera porque mi español no es muy adecuado.
So maybe our interpreter could ask her how much money she could afford for a bond.
Tal vez el intérprete le puede preguntar cuánto dinero puede costear ella para una fianza. ¿Cuánto puede pagar usted de fianza, señora?
Yo soy deshabilitada. Yo vivo de mi cheque. ¿Ya?
I am disabled. I live, I have a fixed income.
Do you have any money in the bank?
¿Tiene dinero en el banco?
No.
No.
Tengo dinero en una tarjeta de crédito.
I have money on a credit card.
How much money do you have on your credit card?
¿Cuánto dinero tiene en la tarjeta de crédito?
Yo creo que no puedo tener como unos 600 o no sé, o voy a pedirle a mi hermana para que me ajuste el dinero.
Around 600, I don't know. Maybe I can ask my sister to pitch in.
Do you have your sister's name and number?
¿Tiene el nombre y el número de teléfono de su hermana?
No, no tengo, no, porque usted sabe, los teléfonos ahora son esos que uno se pone y yo nunca me he aprendido los números del teléfono, ¿ves?
No,
Pero,
you know how phones are now, that that you just punch the numbers in and that's that. So I've never learned any phone number.
pero
Where is your phone, Miss Caldera?
¿Dónde está su teléfono, señor Caldera?
está en la casa, y, ¿cómo la? Y mi hijo, yo creo que puso en el papel ese cuando me trajeron que cualquier emergencia lo pueden llamar a él.
At home, and I believe that my son wrote down on that paper that they gave us when they brought me in that if there's any emergency, they can call him.
Do you know your son's number?
¿Se sabe el número de su hijo?
No, debe estar en los papeles ahí. Yo no sé nada de los números de teléfono porque están puestos en el teléfono mío, y el teléfono mío está en la casa.
No, I don't know anything about any phone numbers. They're programmed into my phone, and my phone is at home.
A mí no me
Do you
dejaron
live
tomar
with the
nada.
alleged
I
victim
wasn't
in
allowed
this
to take
case?
anything. ¿Usted vive con la supuesta víctima en este caso?
Sí, ¿cómo se llama? Yo vivo esa es mi nuera, ¿ya? Y entonces yo tengo 10 años de vivir allí sola con un nieto.
Yes,
¿Ves?
that's my daughter. That's my daughter-in-law. You see, and I've lived there by myself for 10 years with a grandchild.
Y mi hijo, ¿cómo le llaman? Mi hijo vendió la casa de él, y entonces yo dije, okay, que si fueran a vivir a la casa de mi otro hijo.
And my son, how do you say it? He gave me his house, and so I said, okay, go and live in the house that belongs to my other son.
You're
All
not
right.
going to be able to have any contact with your daughter-in-law. Do you understand that?
¿Usted entiende que se le va a prohibir tener contacto alguno
Sí, yo
con su
sé.
nuera?
Sí, yo voy a irme para la casa de mi hermana.
Yeah, I
Okay,
understand.
yo-
I'm going to go to my sister's house.
Okay.
All
Well,
right.
Your Honor, it appears Ms. Caldera, because she has a disability,
Bien, su señoría, parece que dado que la señora Caldera tiene una discapacidad,
does not have a lot of money to post bond in this case.
ella no tiene mucho dinero para pagar una fianza en este caso.
She also has no prior criminal history.
Y tampoco tiene historial penal.
She has a place to stay where she would not be in contact with the victim,
Tiene un lugar donde hospedarse donde no tendría contacto con la víctima.
and she indicates she has about $600 on her credit card.
Y nos indica que ella tiene unos $600 en su tarjeta de crédito.
I would ask the court to consider a $1,000 bond for
Yo le
Ms.
pediría a la
Caldera.
corte que contemple la posibilidad de imponerle una fianza de $1,000.
All right, the court does find probable cause. I'm
Bien.
going to impose a bond of $3,500
Considero que sí existen indicios probables. Voy a imponer una fianza de $3,500
and no victim contact.
y se le prohíbe tener contacto con la supuesta víctima.
Ma'am, that means you don't text, call, write, or try to have a third party contact the victim in this case.
Señora, eso significa que usted no le puede mandar mensajes de texto, no la puede llamar, no le puede escribir y no puede tampoco tratar de contactarla mediante un tercero.
No, señor, yo nunca he tenido ese problema. Llegó la circunstancia hoy, se dio,
No.
estoy aquí, y si la tengo que pagar, bueno, como sea, yo voy a pagar ese dinero.
No, ma'am,
¿Ves?
I've,
Pero
I've
yo no
never,
quiero
I've,
problemas.
I've never had a problem like this before. The circumstances were such that
Don't
this
discuss the
occurred and-
facts of your case.
no hable sobre su caso, señora.
All right, good luck, ma'am.
Buena suerte, señora.
Ok, entonces, yo quiero salir lo más antes posible, ¿cómo yo puedo hacer?
Okay, so when I want to get out as soon as possible, how do I go about that?
Porque yo no tengo los números
Just
de
to post our
teléfono.
bond.
Because
That's
it-
$3,500.
Es pagar su fianza, son $3,500.
Ok, pero si yo no tengo mis papeles para llamar a la casa, no tengo
Okay,
un
but if I
número,
don't have my papers to call my
¿qué yo voy a
house,
hacer?
All right, ma'am,
Your
they'll tell you.
son knows where you are, ma'am.
su hijo sabe dónde está usted, señora.
Sí, pero si no se buscan cómo comunicar conmigo, ¿cómo yo voy
Yeah,
a
but if he
salir?
doesn't get in touch with me, how am I going to get out of here?
Ma'am, your attorney will be in touch with you, your son will be in touch with you, and they will tell you how to get the bond posted.
Señora,
okay?
su abogado la va a contactar, su hijo también va a estar en contacto con usted y ellos le van a explicar cómo pagar la fianza.
All right, good luck, ma'am.
Buena suerte, señora.
Eugenio Gomez Najera.
Paul Run.
Come on, Mr. Go.
Oh, I'm sorry, Judge May. Conte also.
North Broward.
Yeah, North Broward, I'm sorry.
Judge Powell, I also want to bring to your attention, Mr. Gomez is on the second look docket, so we're going to run into the same problem this afternoon.
Jueza Powell también quería señalarle que el señor Gómez también está en la lista de casos de segunda vista, entonces también está para hoy en la tarde.
By the problem, you mean that he'll need a Spanish interpreter?
En otras palabras, que va a
Okay.
necesitar intérprete, sí.
Or I didn't know if you can run them together this morning.
Okay.
O no sé si podía hacer ambas cosas.
This is Eugenio Gomez Nahara.
Este
Yes.
es Eugenio Gómez Nájera.
The only other thing he was being held on, he posted bond, so
Para el único otro cargo que tenía pendiente ya pagó la fianza.
that's what I'm showing.
Eso es lo que me veo acá en la base de datos.
So that's
Si busca este caso, este número de expediente estaba para la lista de casos de la tarde.
So it can be removed from the second look.
Bueno, entonces puede
This afternoon.
eliminarse de la agenda de segunda vista.
All right, thank you. So that
Bien,
solves that
gracias.
problem.
Eso resuelve ese problema.
All right, so Mr. Gomez Najera, you are before the court today for a misdemeanor capias.
Bien, señor Gómez Nájera, usted está ante el tribunal hoy por una orden de captura por una contravención.
This is charge number 3,
Este es el tercer cargo
operating without a valid license.
de operar un vehículo automotor sin licencia válida.
I do find probable cause.
Considero que existen indicios probables.
And did I hear that he already posted bond
Ya pagó la fianza.
on the
Yes, Your
other
Honor.
2 counts?
Parece que para los dos cargos ya pagó la fianza.
He posted a $1,000 bond on a carrying concealed firearm charge.
Pagó una fianza de $1,000 por un cargo de portar arma oculta.
And in light of that, I'd ask the court to consider releasing him on his own
Y
recognizance.
dado este hecho, le solicitaría a su señoría que contemple la posibilidad de liberarlo bajo palabra.
Mr. Linder, was there something you wish to say?
¿Hay algo que desee decir el fiscal?
I just don't think posting a bond on a new unrelated offense should be a basis to ROR him for failing to appear in court.
Simplemente creo que el hecho de haber pagado una fianza por un delito nuevo que no tiene relación con el presente sea un fundamento para su liberación bajo palabra.
This capias is, he did not appear for a court hearing
Esta orden de captura se emitió porque no compareció a una audiencia
on September 24th, 2018.
el día 24 de septiembre del 2018.
And so,
May I say something?
maybe not.
Tal vez mejor no.
And so the court at that time entered a bond of $250.
Y en ese momento la corte emitió o le impuso una fianza de $250.
And so I will leave the bond in place
Así que voy a dejar en pie la fianza
for $250.
por el monto de $250.
All right, good luck, sir.
Buena suerte, señor.
Gracias.
Is there
Thank you.
anyone else who needs a Spanish interpreter?
North Broward's good now.
Thank you. All right, thank you.
Remain, Judge.
All right, thank you. Thank you. All right, all right, someone signed in on Haile Selassie Richards on page 28. Has, but I'm pulling out of turn to,
I wasn't.
Judge, yeah, Richard's on page 28. Just to let the court aware, they're gonna go and get him right now. I just wanted to.
no, don't, once he's there, you let me know. We have a big docket, so it's very difficult to try and maneuver all these things this morning. So once he's there, it's okay. All right, on page 29, we have Paul Jr. Good morning.
Carol, and acting on behalf of Mr. Paul from the Lodges of Briar and Jordan.
Sure.
All right. If you can turn off the mic over at the main jail for a little bit, please.
Yes, Judge.
All right, Counselor, I know you announced before, but I didn't hear, so if you could just do it again, please.
Yes, it's Carol Nafi from the Law Office of Breyer and Jordan on behalf of Mr. Paul.
All right, good morning, Ms. Nafi.
Good morning.
All right, Mr. Paul, you are before the court today. The paperwork says premeditated murder and count 1, and count 2 is possession of a weapon or ammo by a convicted felon.
And Judge, it should be an attempted murder.
That's why I started out that way. Right? So I do find probable cause for attempted murder on count 1, and then also I find probable cause on the possession of weapon or ammo by a convicted felon, and I'll hear from the parties as to bond.
Your Honor, and I do recognize that Judge Murphy set a $500,000 bond on the attempted murder. That being said, the state would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the arrest warrant affidavit stating that Mr. Paul was identified by both the victim and the witness. There's video surveillance capturing the incident, and physical evidence was obtained from the scene corroborating the victim and witness's allegations, specifically a shell casing that was in the area where Mr. Paul allegedly fired his gun at the victim.
Okay.
And Judge, if I may, I would ask the court to keep the bond as set by Judge Murphy. I just want to make the court aware that for the past 3 weeks, Mr. Paul has come to our office. This was initially a search warrant. Our office did contact Detective Graber in order to find out more information. At that time, we did not know there was an arrest warrant. We made multiple attempts to contact her to have Mr. Paul voluntarily surrender. Now, last week, we made an agreement with Detective Graber for him to voluntarily surrender. He's not a flight risk. We took him to the jail yesterday. That's where he was arrested. Now, as far as the affidavit, I did have a chance to review it. I am aware that a shell casing was found. And as far as surveillance, Judge, it does state here that the surveillance captured events occurring prior and after. There's no surveillance actually showing whether or not Mr. Paul shot a firearm. So based on that, Judge, I would ask Your Honor to keep the bond as set by Judge Murphy, and then we could try to take care of it in whatever division it goes to.
All right, I do find probable cause, and I will make a preliminary finding of proof evident presumption great, but I'm also going to exercise my discretion to set a bond, and I will I'll leave the bonds in place for attempted murder on count 1, 500,000, and then the possession of weapon or ammo by a convicted felon, 100,000.
Thank you, Judge.
Your Honor, I would ask for an order of no contact with both Jermaine Butler and Vishal Ramheet.
And so no victim contact and no contact with the co-defendants in this case.
It's a witness, Your Honor.
Right, I don't think there's a co-defendant, Judge.
Witness, no victim and no witness contact.
Thank you.
All right, you're welcome.
And Judge, whenever the court's ready, Mr. Richards has been brought.
All right, hold on a minute. On page 27, we have Al Bernard Isaac, Mr. Moldoff.
Yes, good morning,
Al
Your Honor.
Bernard Isaac. He's on page 27. Thank you.
He's in North Broward, Your Honor.
Thank you.
Brad, your lawyer's here. Just stand on the end right there and listen to the judge.
All right, Mr. Al Bernard, you are before the court. Count 1 is possession of cocaine, and count 2 is possession of weapon or ammo by a convicted felon. All right, I do find probable cause.
Judge, could I be heard on probable cause?
Sure.
For a moment? So, what's confusing to me, this is back on February 20th. When I read through this, it says they walked through the residence with Shanita Isaac, at which point she informed detectives who slept in each bedroom, but they don't say the last time Mr. Isaac slept in the bedroom. Apparently, Mr. Isaac was not in the house, but also there's no time frame of when he would have been there. So the only, so they say they find in a room where Miss Isaac also sleeps a cigarette package with, I guess, some cocaine, and then inside a dresser, a firearm. So if Miss Isaac realized that she was in trouble, or I don't know who Miss Isaac is. I don't know if she has a past, but clearly that room is jointly occupied. You know, the court's, I'm sure, well aware of constructive possession issues, and no temporal evidence about was Mr. Isaac there in a day, a week, a month ago. I don't know how they can establish probable cause that he was in possession of any of those items without some kind of time frame. She says he slept there, but when's the last time he slept there? You know, there's a lot of people in that house. There's numerous people in the house. Just because he sleeps there doesn't mean he knows or isn't even aware of everything that's in the room, where there's another occupant of the room and 3 or 4 other occupants of the house. It would be different if he was there, but you know, they come, and plus I think they came early in the morning, so he's definitely not sleeping there every night. I would just question the probable cause aspect of that.
And when was he actually
And he
arrested?
was arrested on a warrant, the day before yesterday, I think.
It doesn't state what time. I don't believe it states what time of day.
Well, it just has at the top, it says not for, oh, I'm sorry, place of employment, yeah. Right, it doesn't have a time, but typically these are, well, typically they come at a time where they expect to catch everyone in the house. You're right, it doesn't say anything about time at all.
Your Honor, they also found his mail in the room. It wasn't
Right.
just, sir, please.
Oh, no.
That was going to be my next question, but go ahead.
They found his mail in the room. That also, it's not just based on the statement that he sleeps in the room. His mail was found in the room for probable cause, but certainly, if at a later date when there's a higher burden, Mr. Moldoff can certainly make constructive possession arguments. But for probable cause, I believe that there is enough here at this time, Your Honor.
Okay, I disagree. I mean, I realize it's a lower standard, but, you know, even, you know, in a light most favorable to the state, that just shows that he sleeps in a room when, we don't know, how often, we don't know, you know. I mean, let's not disavow everything we know about, you know, men and sleeping around a little bit and not always home and not always at the house where they live.
All right.
I don't get my mail delivered to
I
other
am going
places where-
to make a finding. I do find probable cause. It is a low standard, and there is signs that that's the room that he occupies. I'm sure Mr. Moldoff will make a wonderful argument before the division judge on some motion. So I do find probable cause, and as to bond?
As to bond, Judge, certainly, you know, the cocaine is one thing, but the firearm, I would say, is not something that should have no bond at all. So I would say maybe another $1,000 bond.
All right.
Your Honor, I'm going to be requesting a $3,500 bond. He has 12 prior felony convictions. He has been to state prison. Nothing further.
You know when he was last in prison? Okay.
Are we waiting on
If the court wants to know, I'm not really, you know, anything the court wants to know, I'll be more than happy to ask. Mr. Moldoff, I mean, I'm not his witness.
Okay. When was the last time Mr. Isaac was in custody or in prison?
Your Honor. Let's see. The last time he was in prison was a 2000 case. I also see that he's gone to prison on 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Approximately 14 different cases he's received prison sentences on.
Right, but if they, I don't know if they're all concurrent or what that is, Judge, but if it was 18 years ago, that certainly doesn't speak to him being a flight risk or, you know, to just raise the bond for no reason.
On count one, the bond is $1,000, and then on count two, I'm gonna impose a bond of $2,000. Good luck, sir.
Thank you, Judge.
Yeah. All right. All right, let's, we can handle some of Mr. Sheets' cases. So we have Robin Daly on page 2.
Come on in, Miss Daly.
Oh,
Court proud.
thank you.
Hello.
All right, Ms. Daly, you are before the court on a misdemeanor capias matter. It's a municipal ordinance carrying open container in public.
Correct, Judge. The city of Hollywood offer her a time-served plea.
All right, Ms. Daly, your attorney tells me that you wish to resolve your case today. Is that correct?
Yes, I do. I have not spoken to the attorney yet, though.
Oh, well, he's right on the screen in front of you there.
Hi, ma'am. They're
Hello.
offering you a time-served plea. Would you like to accept that?
How much time would it be?
0 time. Time served. The time you've already
Oh.
done. How about that?
I think that sounds fantastic, mister.
Thank you.
Ma'am,
I apologize, Your Honor. We were
No,
sitting in a
that's
bench.
okay.
no, no,
Ma'am,
no.
don't
Art,
talk
we
about
didn't
it.
realize it was
Don't,
above
ma'am,
place.
ma'am.
There's no point in apologizing. What plea do you wish to enter?
Are you speaking to me?
Yes, no
Yes.
contest, ma'am. You'd like to plead no
Um,
contest.
The one that you said that, no time served or time served.
Now, would you like to plead guilty or no contest?
I really don't even know the difference.
The difference would be you're not saying you did it, you're not saying you didn't do it. If you plead no contest, you'd like to get it over with and go home today. If you plead
Yes,
guilty,
that's-
that's saying you
Yeah.
are guilty.
Yeah, yeah, no contest, please.
Okay.
Ms. Daly, have you had any prior open container charges?
In Florida, no. I was charged.
All
I
right,
got
that just
but I
no.
didn't do
Okay,
it.
just what? Just answer yes or no. Don't talk about any case
No.
or anything. All right.
No.
All right. I do find probable cause, and did she enter the plea? Did you explain that to her?
Yes, Judge. No contest is what she pled.
All right, Ms. Daly. So I hear you. What plea do you wish to enter?
No contest, Your Honor.
All right, I accept your no contest plea, and your sentence is adjudication and time served. Good luck.
Thank you very much, madam.
All right. On page 15, Justin Lowenstrom.
Good from Mr. I'll wait till. Main jail.
He's a person, Judge.
All
Come on
right.
up, sir.
Mr. Lowenstrom is before the court on 10 misdemeanor capias charges.
Judge, due to the number of cases that he has and the number of capiases also, the city of Hollywood wants us to go to the division.
All right, we'll leave the bonds in place, and Mr. Lowenstrom will go before his division judge.
Judge, can I ask him
I
just
do
one
find
question?
probable cause, yes.
Mr. Lowenstrom, do you have any mental health issues?
No, sir.
No, sir? Okay, thank you very much.
All right, good luck, sir. Roy Meadows on page 16.
16. Judge, Mr. Meadows just met the cutoff for time served, please. With his 5 cases.
All right, Mr. Meadows, you're before the court for 5 misdemeanor capious matters. They're all trespassing and open container, open container. So I do find probable cause. Mr. Meadows?
Yes, ma'am.
What do you wish to do today, sir?
I'd like to resolve the plea.
And what plea do you wish to enter?
No contest.
All right, Mr. Meadows, I accept your no contest plea and sentence you to adjudication and time served. Mr. Meadows?
Thank you.
Mr. Meadows, you gotta stay away from these places where they pick you up. So
Yes, ma'am.
you have to try and, make some effort to find, if you don't have a home, to find a shelter or somewhere to stay, okay, sir?
Yes, ma'am.
All right, good luck.
Thank you.
And then Michael Cruz,
Mr. Cruz, come on up, please.
page 16. All right, Mr. Cruz, you are before the court. Count 1 is a misdemeanor capious on a municipal ordinance charge. Count 2 is a civil matter. That's not from magistrate. And count 3 is another misdemeanor capious on a municipal ordinance charge. The civil writ is from the Department of Revenue, and there's a civil purge of $300.
Yes, ma'am.
All right. So what does Mr. Cruz wish to do today?
Judge, for the 2 City of Hollywood cases, it would be a time-served play.
So, Mr. Cruz, we can't resolve the civil matter, but for the 2 municipal ordinance matters, there's an offer of adjudication and time served if you wish to resolve the cases today. Do you want to do that, sir?
Yes, ma'am.
And what plea do you wish to enter, sir?
No contest.
All right, as to the counts 1 and 3, I accept your no contest plea, and your sentence is adjudication and time served. Good luck, sir.
Thank you, ma'am.
You're welcome. And then Joshua Perez.
Thank you, ma'am.
All right. And Mr. Perez bonded?
Yes, ma'am.
Thank you. All right. I believe that's it, Mr. Sheikh.
Judge, I have one that's attached to, that's Mr. McLaurin. That's okay.
Oh.
Oh, there he is. Look.
Good morning, everyone.
Good morning.
It's a time-served plea, Mr. McLaurin. Would you like to accept it?
All right. So, can we go to the top of our docket, or is Mr. McLaurin waiting to call a case?
Judge, it's just one case. I think Ms. Radigan may have already pulled it out. It's Philip White on page 18 of the docket.
And he is here present, Judge at Maine. He has a state offense and city offense, Judge.
Did you pull it out?
Mr. White.
There's too many papers. All right, Ms. Philip White. Mr. White is before the court. Count 1 is a petty theft. Counts 2 is driving while license suspended or revoked. And count 3 is a misdemeanor capious. That's a municipal ordinance matter for possession of controlled substance. So I do find probable cause. What does Mr. White wish to do? The mic's not on.
Judge, good morning. Mr. White is 26 years old. He has 3 children that he provides support for. He's actually employed right now. He works 2 jobs. He is employed at Burger 5, and he also works as a mechanic at his father or stepfather's, as his dad's shop. Judge, he would like to see if he could resolve counts 1 and 3. He's indicated to both Mr. Romero and I that he's working towards getting a valid driver's license. So he doesn't want to resolve count 2 and jeopardize his ability to get a valid driver's license. We were going to ask if the court would ROR him on count number 2 and give him an opportunity to get a valid driver's license. And I was going to ask, as far as count 3 is concerned, the municipal ordinance, if the court would withhold and take judicial notice of the time that he served.
And Judge, speaking Mr. White, he did advise that he could probably get his license within like 90 days. I think he actually went to find out as far as how much fees he would have to pay to get his license reinstated. My understanding is he believes it's somewhere around $4, so he's going to be saving up whatever he can in order to get a valid license. So that is why, considering he's going to have to take on that financial burden, I'm asking on count 2 the driving offense, which is right now a $100 bond if the court would consider an ROR in that matter.
Your Honor, my concern is his license has been suspended twice in the past for failing to appear in court. He's accused of placing a stolen license plate on the vehicle, I would imagine to avoid apprehension for driving on a suspended license. This isn't behavior of someone that the court should have confidence that he will willfully appear in court, considering he also is here on a failure to appear in a municipal ordinance.
Right, he's asked he wants to resolve count 1. Did you have an offer for him?
Your Honor, they're intrinsically linked. I can't plead out one and not the other. It's all part of one incident.
I understand what the state is saying, Judge, and I guess because they're linked, at this time then, since no bond is attached on 1, no request as far as that, we could leave that in place. But I'm still sticking with my request and asking the court to consider ROR on count 2. I believe Mr. White still, though, wants to resolve count 3, Judge.
All right. So, Mr. White, today we are going to, we'll resolve count 3, which is the municipal ordinance matter. And your sentence will be a withhold adjudication and court costs. So, do you wish to resolve that case today?
Yes.
And also, as to your misdemeanor, the state charges, you are going to be before your division judge tomorrow at 9:30. So you can address those matters there. So what I'm going to do is I'll leave the bond in place on count 2. You'll be before your division judge tomorrow. And if you wish to resolve the municipal ordinance today, there'll be a withhold adjudication and court costs.
He's ready to proceed, Judge.
All right. So, Mr. White, if you, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yeah.
All right. You can put your hand down. I know that we've said a lot this morning, so do you understand everything that's going on here today?
Yeah.
You understand that at this time we're only resolving the municipal ordinance matter?
Yeah.
And do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yeah.
Is anyone forcing you to resolve your case?
Can you repeat yourself?
Is anyone forcing you to resolve your case?
No.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
I understand.
What plea do you wish to enter, Mr. White?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence on count 3 is a withhold adjudication and court costs. Good luck, sir. Okay, Marnisha Walker. Marnisha.
Oh, fine, I believe, Judge.
Thank you.
She's in court, Your Honor.
Okay. All right, Ms. Walker is in court. Marnisha Walker is in court. Jean Thomas.
Lord Broward.
Thomas would like to resolve this matter this morning if possible, Judge.
All right, Ms. Thomas, you are before the court for a misdemeanor capious matter, having a permit unauthorized person, and I do find probable cause. Is it true that you wish to resolve your case today?
Yes.
All right, State, do you have an offer for Ms. Thomas?
Yes, documented offers of withholding court costs.
All right, Ms. Thomas, if you wish to resolve your case today, your sentence will be a withhold adjudication, which means no conviction on your record, and you'll have to pay the court cost that's attached to this.
How much is the court cost?
$293.
When would I have to pay that?
I can give you 6 months to pay it.
That's going to be kind of difficult for me because I'm not working because of the high-risk pregnancy. I'm 7.5 months, so it's going to be about 2 months, and then I'm going to have another probably 2 or 3 months to recover, so I won't be working.
I'll give you 6 months, and you see how best you can do. And if you are not able to pay it off at that time, then you can talk to the clerk's office about some extension, okay?
Okay.
All right. So, please raise your right hand as best you can. You swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. And then, Ms. Thomas, you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And have you ever been treated for a mental or emotional illness?
I've been diagnosed, but I never needed medication.
Okay, and so is there anything that's going on with you today that would affect your decision-making today?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs, and you will get 6 months to pay your court costs. Good luck.
Thank you.
You're welcome. Gina Luzzi.
Medical reset.
Medical reset.
All right. Samora Murray.
Judge, she's here present at Maine. She's approaching.
All right, Ms. Murray, you are before the court for a traffic capious matter. You did not show up for your status conference on March 7th, 2019 on a driving while license suspended charge. So I do find probable cause. Ms. Murray does have court on April 11th on this, unless there's something else.
Yes, Judge. I'm going to be asking for the court to consider taking into account Ms. Murray's circumstances, and that's the reason why I'm asking for the court to consider releasing ROR. My understanding, Judge, is in March, she went ahead and basically paid the reinstatement fees and an outstanding ticket, which was, I believe, a total of $253. At this time, Ms. Murray did advise me now she has a valid license. And basically the reason why she missed court, Judge, is because she was trying to get her valid license in order to work and support her family. Unfortunately, had so many things going through her mind, facing the possibility of eviction. She's a single mom supporting her 2 kids. That she was honest with me. She goes, it was just a mistake. I just made a mistake. I failed to show to court. because she didn't want her kids homeless. Fortunately, she's working. She's getting back on track, Judge. Considering it, she has a valid license now. I'm asking the court to consider releasing Miss Murray ROR on this case.
Okay. Does the state wish to be heard?
No, Judge.
All right, Ms. Murray, I'll grant the ROR request. Ma'am, you've got to make sure that you get everything straight and that the clerk does have your correct address and that you show up for court the next time the court date is set. Good luck.
Thank you.
All right. Are we still, Mr. Richards? Did Mr. Romero say?
Mr. Richards is here.
You were ready? Okay.
Yes. Mr. Richards, come on up, sir.
That's Haile Selassie Richards on page 28. Mr. Richards, you are before the court for one count of aggravated assault with a deadly weapon without intent to kill, and I do find probable cause. And I'll hear from the parties as to bond.
Your Honor, I'm going to be seeking a $20,000 bond, pretrial release with a GPS monitor, no victim contact. Concerned based on the allegations that he threatened his sister at gunpoint, threatened to kill her. This is corroborated by family members that were present in the home when this occurred. I would also note he has priors involving violence, 2016. Strong arm robbery, 2015, robbery by sudden snatching and grand theft.
Okay.
Judge, I'm going to be requesting a $5,000 bond on Mr. Richards' behalf. My understanding, and state can correct me if I'm incorrect, I believe the date of offense was last year in September. Since then, I believe there's been no prior, no future sort of altercations. And speaking with Mr. Richards, he is working at this time. He went through an interview, got hired, and he's actually set to start work April 22nd. And he's going to be working for a company called Future Force, in which it's a warehouse job in which he's going to be making about $12.50 an hour. He lives in Fort Lauderdale. I did advise him that the court's going to be ordering a no contact order, and he will abide by the court's order as far as no contact with his sister. He's been living here his whole entire life. He's 22 years old, but at this time, nobody that he knows could go ahead and afford the $20,000. We have no problem as far as him being supervised, but we're just asking the court to consider a $5,000 bond on his behalf.
All I can say is, Mr. Romero asked, I can confirm, we just have a very different view. To me, even going a few years without an allegation of violence isn't comforting.
All right. As Mr. Reedy liked to say, there's lots of things here that we don't know what's going on. That's not in this affidavit, and so I can't speculate as to what else is going on that's not reported in this affidavit. But certainly, what is in this affidavit to arrest is concerning, and the allegations are serious. And so I am going to impose a bond on count one of $10,000, and that's going to be with a level 2 GPS, no victim contact until further order of the court.
Your Honor, as far as no firearms, weapons, I believe that's part of the domestic violence no contact order, so never mind. I forgot that we're
firearms or
I forgot
weapons.
they were doing. Now I gotta give this to Michelle. Yeah.
All right. Okay, good luck, sir.
Michelle.
Deja Johnson.
She's here, present, Judge.
All right, Ms. Johnson is here on a petty theft charge. I do find probable cause.
Judge, at this time, we're going to be asking the court to sign a property order so she can have access to her property so she could self-bond.
Okay. All right, so the bond is $25 and I'll sign that order.
Thank you.
Heidi Hernandez.
North Broward, Your Honor.
Ms. Hernandez is before the court on 2 counts of misdemeanor capias. Ms. Hernandez did not show up for her arraignment on January 10th, 2019. The charges are possession of drug paraphernalia and petty theft. So I do find probable cause. And
Ms. Hernandez indicated to me she would like to fight count 1, the drug paraphernalia charge. I indicated to her that it is possible for us to get a plea on both charges if she was interested in resolving them. She did indicate, however, she does want to fight charge 1. So I'm going to be asking the court to consider releasing her. She did not appear in court because she lives with her grandmother, and her grandmother did not give her notice. And as soon as she found out that a warrant had been issued for her failure to appear, she turned herself in. She's lived here all of her life. She's been living the last 10 years in the same location with her grandmother. She has a job working at Domino's Pizza. She has a good education behind her. And at this point in time, I don't believe she can afford the $1,000 bond that's currently in place.
Normally, is it correct that she turned herself in? Usually they tell me that.
I'll tell you right now, I can tell. I can tell you right now, Judge, I'm looking at the short arrest form, and the location they give for the Coconut Creek Police Department doesn't match to where she was arrested.
Care to explain that, Ms. Hernandez? Did you walk up to a police officer and surrender yourself?
No, Your Honor.
What did you do?
Well, yes, I was walking down the street and Coconut Creek was there, and my boyfriend had gotten stopped.
All right, stop. Don't say anything more. I'm going to leave the bonds at $500 each. Good luck. Dawn Eves. All right, Miss Eves, you are before the court. This is an ad charge, the charge number 4 for grand theft. And I do find probable cause.
Judge, Miss Eves has no bond holds on counts 1 and 2. I'd ask you to leave this bond in place.
All right, so your bond is $1,000 on this charge. Good luck. Shakira Johnson.
That would be North Broward, Your Honor. She's a medical reset, please.
Okay, thank you. What was that?
Count 4, the VOP was signed with a $5,000 bond, not no
All right, but, you know, she's a reset, so is it? All right. Michelle Polinix.
Fastly, you're next.
That's what confinement is saying. All right. Ms. Polinix, you are before the court. Count one is a retail theft, coordinating with others. I do find probable cause, and I'll hear as to your bond.
I'm sorry?
You've been charged with retail theft, coordinating with others, and I do find probable cause as to that charge. And now we have to talk about bond, so I will hear from your attorneys as to bond.
Can you afford $1,000 bond, Ms. Palinkas?
Pulling these in, no, not as of right now. No, I don't.
Is there anyone I can call to come bond you out?
No, I ain't even getting a phone call yet, and my mom's all the way in Port St. Lucie.
You been arrested before?
Yes, sir.
Have you ever failed to show up in court before?
No, sir.
How long you been living where you live now? She has failed?
Probably a couple of months.
Who do you live with?
My mom.
Are you working?
Well, not now, not no more.
There's no one that can post $1,000 bond for you?
No, sir. I don't think so. I didn't get no phone calls yet.
Judge, if she can't make a monetary bond, I'd ask you to consider releasing her pretrial release.
State?
Just to advise the court, she has failed to appear. She was arrested in Broward in 2017 on a capias.
Ma'am, don't say anything. Just let them talk, okay? All right, state.
That being said, based on the totality of the circumstances, I do not have an objection to pretrial, Judge.
Okay, all right. So I will release Ms. Polinese, is how you say it?
Yes, ma'am.
To pretrial supervision. Good luck, ma'am.
Can I ask a question?
Yeah, yes?
Is pretrial is on the band? The ankle monitor?
No, I'm not
No.
ordering an ankle monitor.
Okay.
But you have to report there tomorrow. They'll give you a map.
They're going to give the information that's being handed to you. You must report to the pretrial supervision office within 24 hours of your release. If you fail to show up, if you fail to report, there will be a warrant issued for your arrest. Do you understand that?
Yes, ma'am.
Okay, good luck.
Thank you.
Angelina Vespia.
North Broward.
All right, Ms. Vespia, you are before the court for counts 1 and 2, possession of drug paraphernalia and or use. Counts 3 and 4 are felony violation of probation. Those are no bond holds. I do find probable cause. You will be before your division judge on April 11th, that's tomorrow at 8:30. And you'll be able to address those issues there. The bonds on counts 1 and 2 are $100 each. Good luck, ma'am. Keitha Daughtry.
She should be here in about 2 minutes.
All right, when she gets there, let me know.
Sure, John.
We'll go to Maria Pineda.
She's here, Judge, I mean.
All right, Ms. Pineda is before the court on count 1, burglary of burglary, occupied conveyance unarmed. And count 2 is felony violation of probation. It's a no bond hold. I do find probable cause.
Considering she has a no bond hold, and I'm going to be requesting a $3,000 bond on Ms. Pineda's behalf on count 1.
That's fine, Judge.
All right, so we'll impose a $3,000 bond on count 1, and she goes to court tomorrow at 8:30. Good luck.
Come on, Lisa.
Lisa Finelli.
May I
North
approach,
Broward, Your Honor.
Your Honor.
Yes, sir.
Conversation with the Fish and Wildlife.
All right. There's Miss Finelli.
North.
Ms. Finelli, you are before the court for possession of controlled substance without a prescription.
Yes, it's my first
Ma'am,
felony.
don't talk about anything about priors or your case or anything. All right, just listen. So I've read the affidavit, and then there's a supplemental. We went from one sentence to a couple more sentences on a supplemental affidavit, so I do find probable cause, and I'll hear from your attorney in regards to your bond.
Judge, as Ms. Finelli had mentioned, this is the first time that she's been charged with a felony. She has been a resident here all of her life. She's not going to be able to post any kind of monetary bond. I'm going to ask the court to consider pretrial release with a ROR on this nonviolent offense.
I don't have an objection to pretrial, Judge.
I'm sorry, what was that?
I don't have an objection to
Okay.
pretrial, Judge.
All right, so I will RR Ms. Finelli to pretrial supervision. There will be random drug testing.
You have to show up there tomorrow, so within 24 hours after your release.
All right? And ma'am, if you don't show up, there will be a warrant for your arrest. So I need to let you know that, and also I am ordering random drug testing.
Okay,
All right, good luck.
thank you.
Mm-hmm.
Joanna, 4 and I have daughter here.
All right. So, Ms. Daughtry, you are before the court for retail theft, coordinating with others, and I do find probable cause.
Judge, I didn't have a chance to talk to Ms. Daughtry because they just brought her in, but I don't know if the state has a recommendation.
She's a co-defendant to Ms. Polanese.
Yeah, the difference is, from what I can tell, she's currently on juvenile probation for, looks like at least one felony level offense.
All right.
Actually, I'm sorry, Your Honor, she's, if I could have one moment.
Are these folks here on a case? What kind of interpreter? Okay. Oh, okay.
Michelle? Because those were all dropped. Okay. They were all dropped, it looks like. All right. Yeah, I can also advise the court, she has a history of pickup orders being issued either for failures to appear or for absconding.
She's currently on probation. Scroll down.
I said she's on probation.
Yeah, she's currently on
Right here.
Okay, Ms. Daughtry, your bond will be $1,000, ma'am. Good luck. Maria Guadalupe Ortega. Ms. Ortega, you are before the court. There are 6 counts of felony KPS, and those are all no bond holds and not for magistrate. Count 7 is a traffic KPS matter, and there's a $250 bond. I do find probable cause. You have court dates lined up for tomorrow to appear before your division judge. Good luck.
Thank you.
Chantrell Higgs.
She's approaching, Judge, you hear me?
Ms. Higgs, you're before the court for failing to redeliver a rented vehicle. And count 2 is a felony violation of probation. That's a no bond hold, and you have court tomorrow with your division judge at 8:30. I do find probable cause. And I'll leave the bond at $1,000 on count 1.
Good luck, man.
Lori Brassou.
She's
Your
in
Honor,
court.
North Broward, she's in court. She's in division court.
Okay. Thank you.
Welcome.
Douglas Cox.
Hear me?
All right, Mr. Cox, you are before the court because you have an out-of-state felony hold, and you should be going to the extradition court Tuesday or Thursday of next week. Okay? Okay. Robert Perry.
He's approaching, Judge.
Mr. Perry, you also have an out-of-state felony hold, and you will be going to the extradition court either Tuesday or Thursday of next week. Okay? Bruno Moth.
North Broward. His parents are here.
Is this the person who needs a Portuguese interpreter?
Mr. Moth does not. His parents do. I'm advised we can have a Portuguese interpreter here at 1:30.
It's okay, it's unnecessary.
You don't have to tell me, you have to tell the judge.
Okay, Judge, it's unnecessary.
Where is he?
He's at North Broward.
Okay. Okay, Mr. Moth, good morning. What are you saying,
Good
sir?
morning, ma'am. I said the interpreter is unnecessary. I can speak in English with you.
I think that they were trying to get the interpreter because your parents are here. I don't, we have an obligation to Mr. Moth, but.
Right. I had no trouble at all speaking with Mr. Moth, Judge. His English is fine.
Okay.
And I understand his father speaks English. Okay.
All right. So Mr. Moth, you are before the court today for count 1, which is touch or strike, battery, domestic violence, and then count 2 is false imprisonment. Those are the 2 charges that you were arrested on, and I do find probable causes to those 2 charges. So I'll hear from your attorney and anyone else who wishes to speak in regards to setting a bond.
Yes, Judge. Mr. Moth is a United States citizen. He is a resident of South Florida since 2001. In addition to his parents being here today, he also has a son and a daughter. He has a very good job. He works as an operation manager at a produce factory. He's had that job for 5 years. He pays about $432 a month in rent. From what I understand, this is his first contact with the criminal justice system, either in the United States or anywhere else. This incident took place at his residence. The alleged victim still has some items there. I explained to him that if he's released, he cannot be in contact with her. If she needs to go by and get things out of his house, he cannot be present when that takes place, and he understands that. He indicated to me he could possibly go through a bondsman to get out. I would ask the court to consider a $1,000 bond on count 1, a $1,000 bond on count 2, which I believe Mr. Moth could make. And I don't know if his parents have any input as to that, or whether they'll be able to help him bond out.
Your Honor, I'm going to be requesting a $1,500 bond on count 1, noting that not only did, based on the allegations, that he put his hands on her, he also spit on her. On mess in her face, a $3,500 bond on the false imprisonment, noting that she tried to get past him four times just to leave the residence. He prevented her each and every time, ultimately locking the door. This is corroborated by a witness, Your Honor. And I would note, while it is his residence, it would appear she was certainly at the time invited to reside there. And obviously, I'd be asking for an order of no victim contact.
Yes, Judge, an order of no victim contact is not a problem for Mr. Moth to comply with that. My main concern is him being able to post a monetary bond so he can get out of jail. He is anxious to have his day in court on this. I think the issue as to whether or not there was any spitting that went on is one that's going to be up to be decided somewhere down the road. But again, this did take place at his residence. He does have excellent ties to the community, a good job. He's not a flight risk. He's not a danger to anyone else in the community because, as we know, he's never had contact with the criminal justice system before. So again, I would ask the court to consider very low bonds for Mr. Moth.
All right.
Ma'am,
Yes.
the only thing is, I do not have a son, I only have a daughter.
Okay.
Okay, I misunderstood what he told me then.
All right. Dad, is there something you wanted to say?
No, I'll just say that's about is make his girlfriend, I don't know, any caster because you have in Negboa, you see both talk outside in the home my son. It's not open all time, it's not overcast, nothing about this. You have testimony, you have Negboa and apartment side by side. You see everything just outside, it's door open, it's not about cast.
Okay. All right. I know this is, it's always tough to be in this situation, and I'm sure Mr. Moth appreciates the both of you being here.
Thanks so much.
I do find probable cause as to these charges, and I will impose a bond. Count one, $1,500. Count two, $1,500. And he has to have no contact with the victim in this case. Now, I understand that it's Mr. Moth's place, and based on what I've heard, that she still does have items there. But Mr. Moth, I don't have any control over the victim. So you've got to make sure that you think through this wisely, whatever it is that if she has to pick up stuff is what I mean, is what I'm talking about, okay?
Yes.
Because you cannot have any contact with her.
Is it okay if I have my father and a police officer there and I'm out of there?
That would be perfect. So,
okay.
All right? All right, good luck, sir.
Thank you.
All right.
Judge Powell,
Yes?
I take one on page 20, Mr. Martinez.
Thanks, Judge.
You're welcome. Take care, folks.
He's on page 20.
Eric Martinez?
Yes.
Okay. All right, Mr. Martinez, you are before the court for a petty theft charge.
Yes, ma'am.
Martinez would like to resolve this if possible today, Judge.
Okay, so I do find probable cause, and State, do you have an offer for Mr. Martinez? Did they get the...
I know, is it a recent?
Did you have good parents? You have good.
Offered be adjudication 5 days county jail, Your Honor. This wasn't stealing from a store. He stole an individual's cell phone. Additionally, he's been to state prison, 2011, burglary of a dwelling with a battery, false imprisonment and theft. He violated probation, was sentenced to 69 months in state prison.
Sorry, Mr. Leonard, how much bond were you requesting?
Not bond, offered 5 days.
5 days? Okay. Mr. Martinez, is that what you would like to do? The offer is 5 days, Broward County Jail.
How many more days do I have left to do?
I would guess close to 3.
Is there no other way to get out today? Or no?
Yes, you have a $25 bond.
Well, I can't afford that. I have no money. So it'd be the days?
Judge, he does live with his mom, and lives with his mom in Hollywood. I don't know if the court would consider RORing him.
Please.
Yeah, but I believe the allegations were he was sleeping somewhere. So.
Bench, like 2 in the morning.
Yeah, he was sleeping on a bench. That's where he. So I'm gonna deny the ROR. I can leave the bond at $25, or you can. There's the offer for 5 days in the Broward County Jail.
I'll take the 5 days in county jail.
All right, sir. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, Mr. Martinez. Sir, do you understand everything that's going on here today?
I do.
Is anyone forcing you to resolve your case?
No, ma'am.
And do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
Yes.
And is there anything about that illness today that would prevent you from making an intelligent decision?
No.
All right. Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Martinez? Guilty or no contest?
No contest.
All right. I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence, sir, is adjudication and 5 days in the Broward County Jail with credit for any time served. All right. Good luck, sir. Confinement tells me that you'll be out on Saturday. All right.
Thank you, Judge Bell.
You're welcome. All right. Anthony Adon. Is he back?
Judge, he's here.
Yes.
And from what Mr. Don advised me, he has private counsel, Mr. Scott Hecker, and I believe my colleague was trying to get in touch with Mr. Hecker.
Actually, I think Mr. Lender spoke to Mr. Hecker, Judge, and my understanding was he would be here today.
Now, Mr. Scott Hecker will be here.
He told me about 8:45. Maybe he got held up in another courtroom.
All right. Well, I will leave Mr. Adon until the end, and we'll see if his attorney arrives. Ralphine Joseph.
Okay, so it'll take about 16 days from the time they post your bond.
All right, Mr. Joseph, you
You'll get a court
have
notice in the mail if the state decides to.
2 misdemeanor capious matters.
Correct, Judge. My understanding is Mr. Joseph was here yesterday. I think he resolved municipal ordinance cases. These were outstanding. We're going to be asking the court to consider resolving this matter as well, Judge.
Resisting without violence and trespass. And actually on count 4, that warranty was ROR'd on that, so. He has a bond of $500 on count 3, but he wishes to resolve both cases. Does the state have an offer?
Yes, one moment, Judge. It would be adjudication, time served, no return to Players Sports Bar at 5280 North State Road 7 in North Lauderdale. And that would apply to both charges. The adjudication, I mean.
Judge, he's willing to accept the state's offer.
All right, Mr. Joseph, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yes, ma'am.
All right, sir, you can put your hand down. Mr. Joseph, you understand everything that's going on here today?
Yes, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest. No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served, and also no return to Players Sports Bar in North Lauderdale. Good luck, sir. Gianni McIntosh Jones.
Jones is here present, Judge. Come on up, sir.
I'm sorry, confinement, this is what?
This is the one, the bond is $250. I think the fine says no bond.
Okay, all right, so, all right. So, Mr. McIntosh Jones, you are here on a misdemeanor capias and operating without a valid license. There is a $250 bond that's been attached to the capias, so.
That's what we spoke about. I told you it was a mistake.
Yeah.
Judge, in speaking with Mr. McIntosh, though, it doesn't change our position. And after speaking to him earlier this morning, he wishes to ask the court if the court would consider resolving this matter today.
All right, so State, do you have an offer for Mr. McIntosh?
Yes, one moment, Judge.
Jones.
Withhold court costs.
All right.
He wishes to accept this state's offer, Judge.
All right, Mr. McIntosh Jones, please raise your right hand. You swear or affirm to tell the truth, sir?
Yes.
All right, sir, you can put your hand down. Do you understand everything that's going on here today, sir? Is anyone forcing you to resolve your case?
No, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Jones?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs. Good luck, sir. Tommy Lee Jones.
Mr. Jackson?
Oh, Jackson, sorry. That was, All right, Mr. Jackson, you are before the court for one count of trespassing, and I do find probable cause. What does Mr. Jackson wish to do?
Jackson, he wishes to resolve this case today.
All right, State.
Time served. No return.
All right.
He wishes to accept the state's offer.
All right, Mr. Jackson, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. Mr. Jackson, do you understand everything that's going on here today?
Yes, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, what plea do you wish to enter, Mr. Jackson?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, Your sentence is adjudication and time served and no return to that location. Okay?
Yes, ma'am.
All right, good luck, sir. Willie Borden.
Please approach, Judge. Be careful, sir. It's all right. Take- Mr. Borden's here present, Judge.
Mr. Borden, you are before the court for one count of trespassing, and I do find probable cause. What does Mr. Borden wish to do?
Judge, in speaking to Mr. Borden much earlier today, he wishes to resolve this case.
All right, Mr. Borden. Mr. Borden, can you hear me, sir?
Yes, ma'am.
All right. Mr. Borden, do you have somewhere to live, sir?
No, ma'am.
Do you have any family around?
Yes.
Can you get in touch with your family?
No, I don't.
Okay. Well, Mr. Borden, you've been charged with trespassing today, and I need to find out what it is that you want to do. What do you want to do today? Do you want to resolve your case?
Yes.
All right. But we're going to, I'm going to do an adjudication and time served, which means that you'll get out today, sir. But you can't go back to this location.
Yes.
Do you understand that?
Yes.
So you're going to have to try and make some efforts to find a homeless shelter or somewhere where you can stay so that they don't pick you up for trespassing. All right? So what plea do you wish to enter, Mr. Borden?
No contest.
All right, I accept your no contest plea, and your sentence is adjudication and time served, and don't go back to this place, sir.
Yes, ma'am.
All right, good luck.
Thank you.
Victor Phillips.
Please approach the judge.
All right, Mr. Phillips, you are before the court for a trespassing charge, and I do find probable cause.
Yes, ma'am.
Judge, Mr. Phillips wishes to resolve this case today.
Yes.
All right, Mr. Phillips, I'm going to tell you the same thing that I told Mr. Borden, that you cannot go back to this location, sir.
Yes, ma'am.
And also, if you have family members or friends, or if you don't, a homeless shelter or something, you've got to find one of those places so that they don't pick you up for trespassing on other property.
Yes, ma'am.
All right? So what plea do you, I do find probable cause, what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea, and your sentence is adjudication, time served, and no return. Do you understand that, Mr. Phillips? I can't say that enough. No return.
No, yes, ma'am.
All right, good luck.
Okay.
Matthew Mosley.
Mr. Mosley?
All right.
Here's Mr. Mosley.
All right, Mr. Mosley, you are before the court for trespassing. And just like the two gentlemen before, I can't stress enough to you not to go back to this place, sir. Do you understand?
Yes, ma'am.
And like I said to the other two gentlemen, you've got to reach out to family. If you don't have family, you've got to find a homeless shelter. You've got to try and find a program so that you're not on other people's property. Do you understand that?
Yes, ma'am.
All right, sir, do you wish to resolve your case today?
Yes, ma'am.
And what plea do you wish to enter?
No contest.
All right, I accept your no contest plea, and your sentence is adjudication and time served, and no return one more time to that property. Do you understand?
Yes, ma'am.
All right,
Yes,
good luck.
ma'am. Good luck, sir. Thank you. Thank you.
All right, Mr. Hecker is here. We can recall Anthony Adone.
Sure, you don't. You're Mr.
Good morning, Mr. Hecker. Mr. Adone, he was here previously, and we did find probable cause in absentia because there were several resets.
Yes, ma'am.
So today he's here for a bond determination.
Yes, Judge.
So just so Mr. Adone knows that he's before the court for count 1 is burglary with assault or battery, and then counts 2, 3, and 4 are touch or strike battery.
Is the court able to set a bond on these matters, or does it need to be?
I'm sorry?
Is the court able to set bonds on these domestics, or does it need to go back to judge?
No, I can set the bond.
Okay.
They're
Oh.
we handle all of it. Is it all?
Well, on count one, I'm going to be seeking a no bond, not because it's domestic, but because of the nature of the charge, Your Honor, the burglary with the battery.
I know probable cause has been found in this matter. Ms. Inman is listed as the alleged victim in the matter. She's the one that's retained me on behalf of Mr. Adone. This is the grandmother's house where this incident took place. He has permission to be in there. He had still had belongings there. I know the PC said that they had broken up and given the key back. Mr. Adone is not a flight risk, Judge. He's not a danger. I believe we can construct a bond and put him on pretrial with a monitor and a stay-away order at this point. I don't believe those charges would going to be filed, the first count, burglary with the battery.
Your Honor, what's before the court is the report where she advised law enforcement he did not have permission to enter into the home. I'd ask the court also to rely upon the report involving the battery against Severio Scalzo as he was present. That is related to the burglary with the battery. And he corroborates the victim's version of events, that Mr. Adone entered uninvited without permission. He was acted violently against Ms. Inman. He acted violently against Mr. Scalzo. Your Honor, I can advise you that at the time, Ms. Inman sought a temporary injunction. She voluntarily did not appear for the hearing, but in her sworn affidavit, she advised in obtaining the temporary injunction, and I'm reading directly from this. He has a horrible drug problem. A few weeks ago, he beat me up, but I didn't call the police. I'm afraid for my life. When he's on crack, because he is very violent, he needs drug treatment. And I understand that there's a report that was from an incident that occurred in April. The bird bat occurred in February. And Your Honor, I recognize the explanation she gave for the incident in April. It doesn't really make sense, though. And I am very concerned for this victim's safety. I think whether she hired Mr. Hecker or not, the question is, does the proof rise to a level of proof evident or presumption great? I believe, based on taking both reports for the burglar's battery and the battery together, that at this time, for first appearance purposes, the state satisfies proof evident or presumption great.
Ms. Inman voluntarily withdrew her petition. I happened to read it over there. If she's claiming my client has a crack or a drug problem, this is something that can be addressed on bond. The state's not moving for pretrial detention in this matter, so I guess it's an Arthur hearing at this point. So if the presumption is great, I'm asking the court to consider a release in this matter, $10,000 monetary bond with pretrial lockdown, and a drug and alcohol evaluation follow all aftercare. That would certainly protect Ms. Inman and anybody else until these charges get filed or don't get filed. My belief is they're not going to get filed as charged. They're going to end up as misdemeanors. But my client will be in jail, losing his job and everything else that he has out there for these purposes. So I'm requesting the court to, if you find presumption great, to set a bond, use your discretion and set a bond in this matter with certain restrictions that I've named.
Well, based on these the affidavits that has been presented, there is there's just conflicting statements that were reported to the police. And so I don't find proof, evident, presumption great.
Your Honor, may I inquire what conflicting statements?
Mr. Linder, there is in the report, and I believe you also mentioned it. I can read it to you. There is on this, there's an affidavit, April 5th, and I think on the, just looking at everything in totality, she said that she has injuries present on her body today due to having consensual rough sex with Adon. And even though she's conceding that he did hold her down and choke her, she's also saying, but she consented to it. So, it's just things like that in the affidavit.
And I was just noting, Your Honor,
that's causing for question as to making a finding of proof, evident, presumption.
And Your Honor, and I understand, I was just noting those allegations occurred 5 weeks after the allegations of the burglary with assault or battery. So even if everything she's stating in the second report is true, that doesn't necessarily conflict with the allegations made from February 21st. And that's why I'm noting that there's also a statement by an independent witness corroborating the allegations that she made. And I would also note the black eye that they observed on the April 5th incident was noted from the February 21st incident.
There is again, there's nothing, even in that first statement, there's no report that she gave a taped statement. There's no, I don't find proof, evident, presumption great. I'll set a bond.
Your Honor, I would ask, before the court sets a bond, I would also note that in addition to Ms. Inman, that in the past, three other individuals sought injunctions, orders of protection against Mr. Adon. He's been to prison for drug trafficking in the past. And I can also advise the court that Mr. Scalzo has also sought an injunction order. He also sought one for fear. I would ask, in addition to whatever bond the court deems appropriate, and I'd be requesting a $25,000 bond on count 1 and $5,000 bonds on 2 and 3, that the court also order pretrial release with a GPS monitor.
I'm asking for a monetary bond, but lower than that, Judge. Pretrial is really where the protection is going to come from. If he's on electronic monitor and everything else, I'm asking the court to set a $10,000 on the first, and then whatever we can get to. The family can afford a $20,000 bond, so whatever we can on the other charges, if we can add it up to close to 20 as possible, that would be great.
All right, actually, I was thinking about setting a higher bond than 25,000, so.
Court can set whatever bond the court's comfortable with.
I am going to set a bond of 25,000 on count 1 and then 5,000 on counts 2 and 3. With a GPS and no victim contact. Level 2.
Thank you, Your Honor.
You're welcome. Mike Matire.
Mr. Mateer is approaching Judge Amin.
Mr. Mateo, you are before the court. It's a misdemeanor KPS matter, and I do find probable cause. It is for a battery. You did not show up for trial. So there's a no bond hold that's been placed on this matter. You do have court tomorrow, so I'm gonna leave the no bond hold in place, and you can go before the division judge to discuss this further. Okay? Good luck, sir. Max Monroe.
Judge, I've been advised Mr. Monroe bonded.
All right, thank you. Yvnel Magliori.
Yvnel Maglor bonded as well, Judge.
Okay.
And Judge, in between Mr. Monroe and Mr. Maglor was Mr. Perez. Did you skip him? Or you knew he bonded?
I don't have, I'm just going by the order of the paperwork, and I don't have.
Oh, okay.
Which Perez? What's his first name?
He was in between Mr. Monroe and Mr. Maglor.
What's the first name?
Joshua Perez.
He bonded.
He bonded, is what I'm told.
Yep, he bonded.
Yeah. Jesse LeBron.
Mr. LeBron, come on up, please.
Mr. LeBron, you are before the court for count 1 is possession of cannabis 20 grams or less. Counts 2 and 3 is a traffic KPS matter. I do find probable cause.
Judge, in speaking to Mr. LeBron, he wishes to resolve these matters today.
All right, the state, do you have an offer for Mr. LeBron?
Withhold on 1 and withholds on 2 and 3.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. LeBron, please raise your right hand. You swear or affirm to tell the truth, sir?
Yeah.
Okay, you can put your hand down. Do you understand everything that's going on here today, sir?
Yes, ma'am.
And is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And sir, have you ever been treated for a mental or emotional illness?
No.
Okay, and do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yeah.
What plea do you wish to enter, Mr. LeBron?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court costs. Good luck.
Good luck, sir.
Salvador Morales.
Mr. Morales, come on up.
Mr. Morales, you are before the court for a trespassing, and I do find probable cause.
Judge, it's Mr. Morales. He wishes to have his day in court. Considering this is a nonviolent offense, I'm going to ask the court to consider an ROR on his behalf. If the court's not inclined for a straight ROR, then I'd ask you to sign a property order so he can self-bond.
Your Honor, I'm asking for a bond increase to $500. Mr. Morales is currently on probation for DUI property damage. One of the conditions of his probation is no alcohol or intoxicants. I would note that the officer checked off the alcohol influence box in this matter, and this did occur at a bar.
The docket, oh. All right, Mr. Morales, I'll leave the bond. I've been placed at $100. Good luck, sir. Jeffrey Guindon.
Mr. Guindon, come on up, please. Mr. Guindon.
Guindon.
Jeffrey Todd. Guindon.
Yeah, that's the one I think right here. Oh, it's yeah. Hello. What's last name? Come on,
He's coming up there.
Mr. Guindon, you're before the court for count 1, possession of drug paraphernalia, and count 2 is misdemeanor KPS matter, and I do find probable cause. And the
Judge, in speaking with Mr. Guindon earlier today, he wishes to resolve both offenses today.
It's both drug paraphernalia charges.
Correct.
Does the state have an offer for Mr. Guindon?
Time served.
Very good. He wishes to accept the state's offer.
Oh, I missed it. What was it?
Time
Time
served.
served.
Oh, okay. All right, Mr. Guindon, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yes, ma'am.
All right, you can put your hand down, sir. Mr. Guindon, do you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
You understand you have the right to go to trial. By taking a plea today, you are giving up that right.
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
Not as yet.
Okay. All right. And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
I'm aware of that.
All right. What plea do you wish to enter, sir?
No contest, ma'am.
All right. I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you very much, ma'am.
You're welcome. Cody Rajski.
He's approaching, Judge. He's here, me.
So, Mr. Rajski, you're before the court for a traffic capias matter, operating without a valid license. I do find probable cause. What does he wish to do?
Judge, you can speak to Mr. Rashke. He wishes to resolve this matter today.
All right, state.
Withhold court costs.
All right, Mr. Rajski, please raise your right hand.
He wishes to accept the state's offer.
Do you swear or affirm to tell the truth? Raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you need any more time to speak with your attorney?
No.
You understand the offer that has been relayed to you?
Yes, ma'am.
And that's what you wish to accept to resolve your case? And are you under the influence of drugs or alcohol?
No.
You understand you have a right to go to trial. By taking a plea today, you're giving up that right?
Correct.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is a withhold adjudication and court costs. Good luck, sir.
Good luck, sir. Thank you.
Roderick Barther.
Mr. Barther, come on up, please.
Who's this?
Roderick Barther. Mr. Barther is before the court for loitering or prowling and resisting officer without violence.
This paperwork.
And I do find probable cause.
Judge, in speaking or attempting to speak to Mr. Barther earlier today, I believe he may have a somewhat clean record. I'm requesting an ROR on Mr. Barther's behalf.
All right.
One moment, Judge.
Mm-hmm.
I have nothing to add, Your Honor.
All right, so I'll grant the ROR. Solange Nicholas.
Mr. Nicholas Solage, come on up, please. He's approaching.
Mr. Nicholas is before the court for a misdemeanor capias. Possession of cannabis, 20 grams or less is the charge. This is an old capias from May 31st, 2017. I do find probable cause. What does Mr. Nicholas wish to do?
Judge, I did speak to Mr. Nicholas. I did advise him, considering this is a 2017 case and his possession of cannabis, I could ask the court to consider an ROR. However, Mr. Nicholas did want me to ask the court if he wishes to resolve this matter, so he wanted to know what would be the plea offer.
Okay.
Withholding court costs.
Judge, he wishes to accept this plea offer.
Okay, Mr. Nicholas, please raise your right hand as best you can. You swear or affirm to tell the truth, sir?
Yes, ma'am.
Okay, you can put your hand down. Mr. Nicholas, you understand everything that's going on here today?
Yes, ma'am.
And it is your wish to resolve the case today?
Yes.
And do you need any more time to speak with your attorney?
No, I gotta go. I'm hungry.
Are you under the influence of drugs and alcohol?
I don't have a job, but I drink some beer sometimes, Mr. Duke.
But today, right now, are you under the influence of drugs or alcohol?
No, I get 4 days of sleep in the jail, no alcohol.
Okay. You understand you have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am.
And have you ever been treated for a mental or emotional illness?
No, ma'am.
And aside from the fact that you're hungry, is anyone forcing you to resolve your case today?
No.
All right. And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Nicholas?
No contact. No contact.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentencers withhold adjudication and court costs. Good luck.
It's an extra copy.
Devin Baber.
All run.
Mr. Baber, this is charge number 7. It is attempting to elude law enforcement, fleeing or attempting to elude a law enforcement officer. And I do find probable cause.
Your Honor, Mr. Baber has no bond holds on counts 3 and 6. I'd ask the court to leave the $1,000 bond in place.
All right, so your bond is $1,000 on this charge, sir. Good luck.
Thank you.
Samuel Charles.
Conti, Your Honor. Good morning, Your Honor.
Good morning, Mr. Charles. You are before the court on it's a felony capias for driving while license suspended. It says ROR. Is he being held on something else? Okay. Okay. Because they did issue this capias ROR. All right, good luck, sir. Jack Hunter.
He's here, present, Judge.
All right, Mr. Hunter is before the court. Count 1 is delivering cannabis. Count 2 is distribution or delivery of scheduled drug. Count 3 is possession with intent to sell, manufacture, or deliver scheduled drug. 4 and 5 are no bond holds, not for magistrate. And 6 is distribution or delivery of fentanyl.
I believe we're just here on 6.
Yes, Mr. Hunter was your magistrate yesterday. He was magistrate on counts 1 through 5.
So.
And now he's here on count 6.
So he's only here for 6?
Yes, you actually ordered the no bond hold on 4 and 5 yesterday in a violation of pretrial.
Okay. All right, so he'll be going to his division judge tomorrow at 8:30, and the bond on count 6 is $2,500. Good luck, sir. Joseph Magana. So, Mr. Magana, you're before the court. Count 1 is a violation of probation. That's a no bond hold. Count 2 is driving while license suspended, and count 3 is a traffic infraction not for magistrate. I do find probable cause, and your bond on count 2 is $750, and you go before your division judge tomorrow at 8:30. Good luck, sir. Richard Ball.
Medical reset.
Okay. Benjamin Stevens.
Please approach the judge.
All right, Mr. Stevens, you are before the court. Count 1 is possession of controlled substance without a prescription, and count 2 is possession of drug paraphernalia. And I do find probable cause.
Judge, in speaking to Mr. Stevens, we're going to be requesting that the court consider releasing Mr. Stevens straight ROR or in the alternative ROR to pretrial release. He's basically, his whole entire life, he's 34 years old, except for the part that he served in the United States Air Force from 2004 to 2007. He is going to school right now. He goes to Broward College where he's studying IT, and he lives in Pembroke Pines with his parents. My understanding is he has contact with the criminal justice system, but I believe it's been about over 5 years. So considering this a nonviolent offense, that's why we're requesting ROR or in the alternative ROR to pretrial.
I don't have an objection to pretrial, Your Honor. Yes. Yes. For what? Your Honor, in light of that information, the state would oppose non-monetary release.
Judge, I didn't hear the information.
We're being advised he was released.
You gotta let Mr. Romero hear, or Mr. Stevens hear what we're saying over here.
We're being advised he was released from state prison in Kentucky in 2017 for a burglary.
I've never been to Kentucky. I'm sorry, I've never been to Kentucky.
All right.
If we can put this on recall, Judge, I can put his data in the system and see what I come up with.
All right, so let's just verify that information. We'll recall Mr. Stevens. Tony Wells.
Mr. Wells, come on up, please.
Mr. Wells, you're before the court for battery on a person 65 years or older. And count 2 is battery causing bodily harm. I do find probable cause.
Judge, I'm sorry, I'll let the state go.
Your Honor, I'd be requesting a $10,000 bond on count 1. No victim contact with Naomi Kennedy, and one moment. Martell Lewis. I would note, Your Honor, he was Mr. Wells was extradited to Broward from the state of Georgia.
Okay.
Judge, that is correct. He was extradited from Georgia. He's been in custody approximately 16 days. He didn't know of this outstanding matter here in Broward County. Right now he is living and working in Georgia. He's working at McDonald's where he's been employed there for about 3 months, making $7.50 an hour. He lives in the city's called Statesboro. He lives in an apartment with him and his girlfriend. His girlfriend also works at the same McDonald's. Their monthly rent is approximately $350. My understanding is that I believe the date of incident was somewhere in late 2018. Judge, he believes that he gave me the phone number of his girlfriend. I'm going to be contacting her after court. He believes if the court sets a bond somewhere in the neighborhood of $2,000 on count one, that she may be able to afford to post this bond using the services of a bondsman. So that's what we're requesting, $2,000 on one, $1,000 on two, for a total of $3,000 on Mr. Wells' behalf.
There's also no mention, I believe, of the victim's age in the probable cause affidavit.
Your Honor, I can advise you this is a filed case. I checked the sworn information, which I can provide the court and Mr. Reedy a copy of, where it's sworn to by the state alleging the victim is over the age of 65.
Yeah, and even though the affidavit didn't say her age, it did say that she is over 65. All right, I do find probable cause, and I am going to impose a bond of $10,000 on count one, and I'll leave the $5,000 on count two. No victim contact. There are two victims. The names are, again, it's Mr. Lewis and Miss Kennedy.
Yes, ma'am.
Yes. 1,000. Yep. Christopher Wooten.
Mr. Wooten is here present, Judge Amin. He's approaching and he's defined the services.
Yeah, just let me know when you're ready.
Mr. Wooten, you're before the court. Count one is an out-of-county hold, felony hold. That has a bond of $50,000 attached to it, and it's not for magistrate. Counts 2 and 3 are felony capious matters. Those are no bond holds, not for magistrate. Count 4 is domestic battery by strangulation. Count 5 is grand theft. Count 6 and 7 are misdemeanor capious. And count 8, traffic capious. And count 9 is a traffic capious.
Your Honor, the state is requesting a $10,000 bond on the strangulation. In an abundance of caution, no contact with Kenyelle Floyd. I would also note, and I confirm with confinement status, he also is on loan. He has an out-of-state hold.
Okay. So as to count 4, I am going to impose a bond of $10,000. And then the bonds on the other counts will remain, and then there are others that are not for magistrate. It looks like you have court tomorrow and Friday in your 2 separate divisions. Okay?
Okay.
All right, good luck. Devin Sally.
Medical reset.
Wilford Morgan.
Morgan, come on.
Remember, page 33. 33. No, stay there. Mr. Morgan is approaching, Judge.
Mr. Morgan, you're before the court. Count 1 is resisting officer without violence. Counts 2 and 3 are traffic capious matters. Count 4 is a violation of community control. Count 5 is the same, felony violation. Those are 4 and 5 are no bond holds, and you will be before your division judges tomorrow and Friday as well. I do find probable cause, and I will leave the bonds in place, the standard bonds in place on the other counts. Good luck, sir. Shelton Graham.
He's approaching, Judge.
All right, Mr. Graham, you're before the court. Count 1 is possession of cannabis 20 grams or less. Count 2 and 3 are felony violation of probation, and those are no bond holds. I do find probable cause. Your bond on count 1 is $100, and you should be before your division judge tomorrow on the violation charges. Good luck, sir. Roy Barnes.
Mr. Barnes is approaching, Judge.
All right, Mr. Barnes, you're before the court. There are 4 counts of possession of weapon or ammo by a convicted felon. Count 5 is possession with intent to sell, deliver, or manufacture cocaine. Count 6 is traffic infraction, not for magistrate. And then 7 is a violation of felony probation. That's a no bond hold. And you're going before your felony judge tomorrow. As to in regards to count 5,
Your Honor, if I could be heard.
yes.
I'm going to be asked, oh, did you say count 5 or?
Is it the possession with intent to sell?
Oh, okay, I'm sorry, I apologize. I was going to be addressing counts 1 through 4, so I.
Right, on count 5, it mentions that there were 6, where is it? 6 pieces of crack cocaine. But that's all that it says in regards to, I don't know the weight, I don't know.
I'm fine with the court, if the court is inclined to make a probable cause finding for simple possession, I don't have a problem with that.
Okay, so I do find probable cause, as stated in 1 through 4. On 5, it's going to be a possession. I'll make a finding for possession. And then I'll hear as to bond.
Thank you. Your Honor, on counts 1 through 4, I'm going to be seeking a $10,000 bond on each count, noting that Mr. Barnes is alleged to be in possession of 4 firearms while he's a convicted felon. And also noting, Your Honor, he is on probation for, he's on probation not only for 2 punishable by life offenses, that being 2 counts of armed burglary of a dwelling, but he's on probation for 1 count of possession of a weapon by a convicted felon.
Judge, I'm going to be asking quite a bit lower. I'm going to be asking for a $1,000 bond on counts 1, 2, 3, and 4. Considering on count 5, PC was found for simple possession, I'd ask for a bond reduction from $2,500 to $1,000. And speaking of Mr. Barnes, he's 36 years old. He is employed. He works for a company called West Side Paint and Body, where he makes approximately about $300 per week. He lives in North Lauderdale with his wife. Their monthly rent on the apartment is about $1,600, and his wife is employed, and she works as a caretaker. Judge, I do see that he has a no bond hold on count 7, but we're going to be asking for $1,000 on counts 1 through 4.
All right. I'm going to impose a bond of $5,000 on counts 1 through 4. I will impose a bond of $1,000 on 5. Robert Robinson.
Judge, he's approaching. He's here at Maine, and he declined to serve as a public defender.
Yeah, but my lawyer.
Oh, who's your lawyer? Tom.
Steve.
Steve who?
Start with a M.
Steve Melnick?
I think that's him.
Who hired him?
I always had him on my probation. I just always called him when I get in trouble.
And you think it's Steve Melnick?
He's on 6th Street.
Judge, Mr. Robinson, he declined, but he advised me he has an attorney called Steve. He's not sure about the last name. He's here locally from what he advises.
Well, if he represents you on the cases that you're on probation for, it doesn't necessarily mean that he represents you on these new charges. So unless somebody hired him for this,
I didn't hire him yet, but
okay.
No, I'm hired, but I need the proof for right now.
Okay. All right. So you are before the court, sir, today for count 1 is possession of cannabis 20 grams or less. Count 2 is possession of oxycodone. Count 3 is resisting officer without violence. Count 4, resisting officer with violence. Count 5, tampering with or fabricating physical evidence. Count 6 is a traffic infraction not for magistrate, and count 7, it's a violation of felony probation. That's a no bond hold, and you will be before your division judge tomorrow. So if that attorney still represents you, they'll be in court with you tomorrow on the felony charges. I do find probable cause. And we need to talk about bond.
The state would request, though, a $1,000 bond on count 4.
Okay?
Nothing from the defense, Judge.
All right, so I'm gonna impose a $1,000 bond on count 4, and the remaining, the other bonds will stay.
And if Your Honor wishes, I believe we're ready to proceed on Benjamin Stevens' case.
Who is Benjamin Stevens?
It was put on for recall.
Oh.
I wanted to pull it.
You were looking for, yeah.
Yes.
All right, can we recall Benjamin Stevens?
Your Honor, there is no history out of Kentucky. I'm going to be asking if the court is inclined to release Mr. Stevens on non-monetary release, that he be supervised by pretrial with random testing. He does have a history with substance abuse. It appears there's been substance abuse issues in the past.
Okay, thank you. All right, Mr. Stevens, we verified some information, and so I'm going to grant your pretrial, your release to pretrial supervision. That, sir, is going to include random drug testing. Okay? The information that's being handed to you, it means that you must report within 24 hours of your release, and failure to do so, a warrant will be issued for your arrest. So RR to pretrial. Jermaine Bowens.
He's approaching, Judge.
Good morning.
Good morning, Mr. Bowens. You're before the court for a grand theft, and I do find probable cause.
Judge, I did advise Mr. Bowens he has a $1,000 bond on this case. From what he advised me, there's nobody that's going to be able to post his monetary bond. He's 35 years old, been living here in South Florida his whole entire life. He just got a job. He's working at Payway, where he just started as a dishwasher, and he's getting paid about $9.50 an hour. Now, he lives locally here in Pompano Beach with his grandmother, where he's been residing basically his whole life. From what he informed me, his grandmother's not working at this time, and she cannot afford to post his bond. Judge, considering this is a nonviolent offense, I believe it was from JCPenney in which merchandise was recovered, I'm going to be asking the court to consider releasing him on standard pretrial release.
Just to advise the court, Mr. Bowen's criminal history: 2015 theft, 2013 dealing in stolen property and false ownership info in a pawn item, 2014 domestic violence battery by strangulation, aggravated assault with a deadly weapon, and battery. He violated probation. He has been to state prison. Those are from 2006 cases out of Hillsborough County for sale, delivery of cocaine, and possession of cocaine. Nothing further, Judge.
Okay.
So, Judge, he does have contact, but as you can see, it's been several years he's been clean and out of trouble. So, asking for pretrial.
All right, I'll grant a release to standard pretrial supervision. Good luck, sir.
Jail, walk across the street, but that's where you have to go. They'll probably be cleared by the time you get out today. You report there tomorrow first thing in the morning, and there'll be a warrant issued for your arrest, okay? Yeah, be there.
John Velkovsky.
Mr. Velkovsky. He's here, President Judge.
All right, Mr. Velkovsky, you're before the court. You've got 3 traffic capias matters and 1 felony violation of probation. There is a bond on count 1 for $1,000. Counts 2 and 3, looks like you were ROR'd on those. Count 4 is a no bond hold, and you should be before your division judge tomorrow at 8:30. Good luck, sir. Louis Ferry.
Mr. Ferry is here present. He advised us that he has private counsel, Mr. Orlando Bush, I don't know if my colleague.
Orlando
Mr. Bush is standing by to appear by phone, Judge.
All right. What's Mr. Bush's number?
954-462-4120.
Hello,
Good morning. Is this Mr. Bush?
this is Orlando Bush, yes. Good morning, Judge.
This is Judge Jackie Powell, and we're calling from First Appearance Court. I believe that
Yeah.
you are the attorney for Louis Ferry.
Yes, I am, Mr. Ferry.
All right, Mr. Ferry.
I turned him in yesterday to the lead investigator in this case, yes.
Okay, so you are aware that he is before the court for aggravated battery causing bodily harm.
The allegation states.
I know.
I'm not saying whether it's correct or not, but that's what the allegation states, yes.
Okay. So just so you know that I don't know if you're on a cell phone, but it keeps going in and out. So.
I apologize.
All right. So I do find probable cause as to the charge, and if you wish to be heard as to bond.
Well, there was a bond set at $1,000. And obviously, both sides of the story haven't been investigated yet, but there is a very reasonable explanation as to what occurred there. So we have another video that's come up, but we'll be glad to provide it to the state. They're cooperating because he turned himself in. My client Mr. Ferry has lived here all his life in Florida. He has lived here. He has taken every reasonable step to cooperate with the authorities. He turned himself in yesterday to the lead investigator. He is communicating with me. I have known his family personally for over 20 years. And really, we would just ask the court to stick with the bond that it originally was set in this case.
Your Honor, the state is requesting a $50,000 bond, pretrial release of the GPS monitor, no victim contact, an additional release condition that Mr. Ferry not be permitted to drive a vehicle until further order of the court. Your Honor, based on the probable cause affidavit, the video speaks for itself that Mr. Ferry ran down this victim, first acting as though he was allowing the victim to pass, and then when the victim basically crossed past his vehicle, he turned his vehicle into the victim, striking him, breaking his leg. I know Mr. Bush is advising the court that Mr. Ferry couldn't be more cooperative. Well, he knew he struck someone and left them at the scene, never once contacting law enforcement, never once contacting 911. He was aware of what happened because based on the conversation with Mr. Ferry's mother on April 4th, he discussed the matter with his mother, advising her that he struck this person. It does list his explanation. The video does not support his explanation in the least. Your Honor, I would also note Mr. Ferry's criminal history. 2017, possession of alprazolam. He went through drug court. The charge was dropped in September of 2018. 2004, possession of cocaine, felony possession of cannabis, and, Your Honor, in 2000, a battery in possession of cannabis. Your Honor, I do consider...
Hold on. Counselor, hold on. He's not done.
I do consider Mr. Ferry to be a danger to the community based on this inexplicable act of violence, even if we go with the explanation he gave his mother, that somebody outside standing in front of someone's vehicle yelling at them is not grounds to run them over and run them down. He could have got, if he was truly in concern for his safety, and I don't necessarily believe that to be the case, he could have gone in reverse. He had other options. If this was a matter where he wasn't intending to cause harm, there would have been no issue with calling 911 once he was drove a safe distance away and advising them of what happened. Neither of those things occurred. Nothing further, Judge.
Okay, that's something that I would expect the state attorney to say, Judge. However, if I'm not mistaken, I don't believe that the state attorney is familiar with a new video that we intend to turn over to the police. And we showed it to the investigator yesterday. It wasn't full of sound. You know, the video that I initially saw was Channel 10 video. Oh, what a heartless man. How could he do this? Well, he could do this. He could do this because this, Mr. Ferry went back. This individual that was injured, allegedly, because he got, if you saw our video, he got up and he walked away. But this man that was walking with a knapsack, the alleged victim, was beating another person, another homeless individual that the police knew about. I don't know if the state attorneys listed him or did bother to call him. They inquired what the alleged victim in this case was doing to him. He was literally beating the crap out of him at a bus stop when Mr. Ferry came back. If you look at the video in this case, the alleged victim turned around and was heading towards Mr. Ferry. And it wasn't that Mr. Ferry went out and hit him. Yep, you know what? A lot of people, a lot of things have happened, but what the state attorney is not saying is not correct. And, you know, it wasn't that my client was trying to run him over. My client would never do something like that. And most rational people that analyze the case and analyze the events prior to the events wouldn't jump to such conclusions. The reality is that the alleged victim in this case was beating somebody up at a bus stop. There were several people there. My client went back to see what had happened, how the real victim in this case was doing, and that's when this gentleman came up. My client didn't want any problems with him. He came in. He was coming around. He was turning around towards my client, and you know, and then my client was afraid for his life. This guy is a very fit individual. He's 46 years old. You know, I just wish that they would investigate these cases better. My client is not a danger to himself. He's not a danger to others. He's not a risk of flight. He's an American citizen. The only place he has to go is his mother's apartment, who lives here and who has lived here for many, many years, more than 20 years. That's all. You know, we're not asking for him to have no bond. We're asking the state attorney to investigate this case more thoroughly, because I have listened I have listened to various videos of these hysterical news reporters that are inside the community into believing that my client was somehow a harmless sociopath, which he's not. You know, he works.
Okay, Mr. Bush, this is a first appearance, and the standard here is probable cause, as you know, and based on the allegations in the four corners of this complaint affidavit that has been presented to me, that's what I need to use to make a determination as to whether probable cause exists. And then, you know, we're talking about bond, and I've heard what you said. It sounds like you will have you'll have motions to file before his division judge to be heard at a later time. But as for today, I do find probable cause. I am going to impose a bond of $50,000, and I'm going to also impose a level 2 GPS. No victim contact, and
Judge, giving him $50,000 is tantamount to giving him no bond, which, the appellate court just said that it's wrong.
Well, I have more than just the consideration to make as to the what he can afford, and as you are aware, the statute does give me over 20 different considerations, and based on the allegations, that's the bond that I'm setting at this time. All right. Did I? Okay. All right. Good luck, sir.
Your Honor, and
Yes.
before Mr. Bush goes, sir, could you have deputies? The only other request I made based on the allegations is an order of no driving until further order of the court.
Well, Judge, thinking, if the concern is danger to the community, would the court impose a pretrial release with the strictest conditions? Because he has to work, he supports his mother. His father passed away a few years ago, and he's the one that really takes care of his mother. We're requesting that the bond not be imposed so highly.
All right, sir, I've heard the argument, and I've made my ruling is $50,000 with a level 2 GPS and no driving until further order of the court. Good luck, sir.
Well, Judge, if it pleases the court, he's a delivery man. Would the court allow him to drive for purposes of business?
Mr. Bush, what I'll say to you, sir, is if that is a consideration, a concern, then you need to file the appropriate motion with the division judge, providing all the information about what he does and what times that he needs to be at work and all of that. Okay?
Thank you, Your Honor. Have a nice day.
You too, sir. Good luck. All right, Tyler Robbins.
Mr. Robbins is here on main judge approaching. Come on up, sir.
All right, Mr. Robbins is before the court for one count of premeditated murder. Is this also an attempt?
Yes, Your Honor.
Okay.
And I can also advise the court, he's here on the arrest warrant, but the state has filed an information, a non-custody information.
So I'm making a finding for the attempted murder.
Yes, ma'am.
And then I'll hear as to bond.
And the reason I was bringing that up is it's an explanation why his assigned judge, Judge McCarthy, has done the transport order on the given case number.
Okay.
Your Honor, the state would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the affidavit, Your Honor. The incident in its entirety was captured on video surveillance. Mr. Robbins was identified by a person that is personally familiar with Mr. Robbins. A co-defendant made incriminating statements to this witness. Also, I would note that Mr. Robbins was identified by the victim in the case as well.
All right.
We would object to the court making a finding of proof evident presumption great at this time. It's the highest standard of proof we have in the criminal justice system. Based solely on this affidavit, our position is that there is insufficient evidence to establish proof evident presumption great, and we would ask the court to set bond for Mr. Robbins.
All right. I do find probable cause based on the affidavit to arrest and the information provided therein in regards to that this incident was captured on surveillance video, that the witnesses provided sworn statements, and that there were positive identification. I find that there is sufficient information to make a preliminary finding of proof evident presumption great. This denial of, and I'm going to hold the defendant no bond, This denial of bond is without prejudice for Mr. Tyler to file a motion to set bond and request a hearing under State v. Author. All right, Andrew Robinson.
Judge, he's approaching us here at Maine, and he declined the services of public defender. Oh, you want to go? Okay. Judge, he changed his mind. He's going to go with the public defender.
All right, Mr. Robinson, you are before the court. Count 1 is driving while license suspended. Counts 2 and 3 are traffic keepers matters. Count 4 is an out-of-county felony hold. That's a no bond and not for magistrate. I do find probable cause.
Judge, my question is in reference to count 2. It's an operating without a valid license, a 2011 case. There's no bond. Is that correct?
That's what the keeper says, issued by Judge Hurley.
Judge, I'd ask you at this time, considering it is a 2011 case, and it's an operating without a valid license, at this time, I'm going to ask the court to consider setting a bond of $500 on that count.
One moment, Your Honor.
This keeper was issued August 15, 2017.
If I could just, I just want to see what type of hearing it was that Judge Hurley ordered the no bond. Okay, the reason he said it at no bond is because he didn't show up for a violation of probation hearing.
So he was on probation on this traffic matter?
Yes, Your Honor. It was before Judge Fry, and then he was supposed to appear before Judge Hurley for a status conference on a VOP that had been going on, and he just didn't appear.
So he's on probation on that 2011 case?
Yes. All right, I'm going to leave the bond in place, and I don't know when he's going to court on the traffic keepers matters. Count 4 is a out-of-county felony hold, so. All right, good luck, sir. Ronnie Reed Denegal. All right, Mr. Denegal, you are before the court for count 1 is a burglary on occupied dwelling unarmed, and I do find probable cause.
It's the police report here says investigation revealed that that the two co-defendants went into the house, pried the screen off, broke into the master bed. It doesn't say what evidence there is to support that. I think just saying, well, the investigation revealed that this is what happened is insufficient for purposes of probable cause without something more substantive.
Well, they received a call of a burglary in progress.
Yeah, Your Honor, they were found minutes after fleeing from the home in a car that a witness identified them as both of the fleeing in.
That's extremely circumstantial, and it is not evidence that Mr. Reed or Mr. Ellis actually did the breaking into the house.
Your Honor, calling it circumstantial that's not a defense to probable cause. Circumstantial evidence can support probable cause just as much as direct evidence.
All right. I'll rephrase, there's no evidence.
Okay?
There's evidence that they're in a car, seen leaving the area.
No, not the area, the scene of the burglary.
All right, I do find probable cause. Let's talk about bond. Does anyone wish to be heard as to bond?
Oh, one moment, Your Honor. Your Honor, I'm sorry, I just need to check. Your Honor, he has multiple like offenses as a juvenile out of the state of Jacksonville. Out of Jacksonville. It's been a long morning. Your Honor, my other concern is simply that it would appear both he and his co-arrestee reside in Jacksonville, and they're down here in Broward County, in this instance, allegedly breaking into a home.
Okay.
I'd be requesting a $15,000 bond. No victim contact, no return, no contact with his co-arrestee, Javavian Ellis. Yes.
All right.
Judge, Mr. Reed's been residing here in Florida his whole entire life. Judge, at this time he is working. He works in landscaping. He lives with his brother, and their monthly rent at the apartment they've been renting out for the past 6 months is approximately $900 per month. Now, he did give me the phone number of his mom, who I'm going to be reaching out to post his monetary bond. We're going to be requesting a monetary bond of $5,000, and we're going to be asking the court to take consideration what my colleague argued as far as mitigation in terms of.
All right, find probable cause. I'll impose a bond of $5,000. No victim contact and no contact with the co-arrestee, Mr. Ellis. Good luck, sir. All right, let me just handle Mr. Javavian Ellis, and then I'll go to Mr. Cummings.
Mr. Ellis is approaching, Judge.
All right, Mr. Ellis, you're before the court for a burglary, unoccupied dwelling unarmed, and I do find probable cause. And I'll hear as to bond.
I would be requesting, Your Honor, I'd be requesting a $10,000 bond, but I understand if you're inclined to set the same bond as his co-arrestee. He has lack of ties to the community. Would just ask that the court order the same release conditions, no return, no contact, and no contact with his co-arrestee.
Judge, and speaking of Mr. Ellis, he's also been living in the state of Florida his whole life. My understanding, and the state will correct me if I'm incorrect, this is his first arrest. He lives in Jacksonville, where he is a registered voter. He works, he's employed, he works at the racetrack gas station. He's a cashier. He's been there for about 1 year now, making $9.50 an hour. Now, he lives with his mother.
Actually, I live with my mom, but I don't at the same time. It's complicated, sir. It's complicated.
It's from what he's telling me, Judge, I guess things with his mom is complicated, but he did give me his phone number of his mother, Angela, who I'm going to contact after court, and he believes that she's going to assist in helping set his bond. If the state can confirm, Judge, that This is his first contact with the criminal justice system. I'm going to be requesting a $2,500 bond on Mr. Ellis's behalf.
I don't see a prior arrest. I also see, it seems that he could potentially be facing a first-degree felony with enhancements, considering it would appear he came from out of county to commit this burglary.
So I'm going to impose a $5,000 bond, no victim contact, and no contact with the co-arrestee. Good luck, sir. All right, Mr. Martin, on page 35, Lazaro Cummins.
Thank you, Your Honor. He does have a standard bond. I believe it's reasonable at this point. It's only $750. I'd argue to reduce it, but I think he'd have to put the same amount up to the bondsman. We're happy with the standard bond of $750, Your Honor.
All right, so Mr. Cummins, you are before the court. Why are you standing? Mr. Cummins, you're before the court. Count 1, driving while license suspended. And count 2 is a traffic infraction. I do find probable cause. Does the state wish to be heard?
One moment, Judge. I just want to see what he's out on. Yes, Your Honor. I'm requesting a $2,500 bond. He's out on a DWS habitual offender.
Your Honor.
Yes, ma'am.
Mr. Cummins is currently on pretrial supervision in case number 180067866CF10A, driving while license revoked, and unlawful license tag or sticker attached. At this time, we're requesting a revocation of his supervision.
Just so the court's aware, I see he's pled out 3 DWSs in 2017 with DUIs in 2014, 2011, and another in 2011.
Your Honor, the defendant has ties to the community. He's a longstanding resident. He actually has a young child who he supports and a significant other. He has residency. He has full-time gainful employment, which he wishes to keep.
When was he placed on pretrial?
August of 2018.
Okay. And this is the first, is there any previous violation or revocation?
Wait a minute.
As to case number 18-006-786 CF10A, I am going to revoke his pretrial supervision, but I'll impose a bond of $250 on count 1. The count 2 is a traffic infraction. And then on the new arrest, the bond will be $750.
Thank you, Your Honor. We'll take care of it in division.
Okay.
See you soon, Lazaro.
All right, Justin Brennan.
Please approach him, Judge. He's here, Judge.
All right, Mr. Brennan, you're before the court for possession of controlled substance without a prescription. And then you have 2 counts of felony capias. Those are no bond holds and not for magistrate. I do find probable cause. On Mr. Brennan? Oh, I did have a, okay. All right. All right, finding probable cause, I'll leave the bond of $1,000 in place, and it looks like Mr. Brennan has court tomorrow. And then Mark Guillaume.
Mark?
Guillaume.
Bonded.
Bonded. Francis Ginty.
He's approaching, Judge.
All right, Mr. Ginty, you're before the court for burglary, unoccupied dwelling unarmed. I do find probable cause. All here is the bond.
I thought it seemed more like a structure to me.
Well, it was a pool.
A common pool area.
House.
I think a storage room and a public bathroom.
It's not
I don't
attached
see
to a
it
house.
going
The
in
entire
anybody's
property,
home.
they're townhomes, so the property
That's
itself
what I was saying is attached to
is a residential property. And that is within, it would appear that's within the curtilage of the residential property.
But it's not actually where anyone lives. It's the storage room and the pool house.
Again, contained within a residential property.
If you break into somebody's shed in the backyard, it could be considered burglary of a structure.
Yes,
this
but
isn't any
also
different.
if the shed is within the curtilage of a residential property, it could also be considered burglary of a dwelling.
If it's enclosed.
And it doesn't say it's within the curtilage of the property.
All right, I don't know. I don't know.
These are townhomes. How could a pool house be outside the curtilage of a townhome property?
Mine is in my townhouse area.
So you're, okay, it's the pool house is on another piece of property.
All right. I do find probable cause. You can do your investigation and take your pictures and file your motions.
It's certainly something the court can take into consideration for bond.
Let's talk about the bond.
Your Honor, state would be seeking a $5,000 bond, no return. Yeah. Well, not anymore.
Judge, we're not far off. I've been speaking to Mr. Genti, and he believes his family can come up with some money. He believes they can come up with about $300. We're going to be asking for $3,000 bond on his behalf. He's 26 years old. He is working. He works at the Sentinel Casino. He's been there. He was just hired, and he's making about $11 an hour. He lives with his parents, both his mom and his father, in Dania Beach, where they rent. They don't own their apartment. His father's a roofer by trade, and his mom is a stay-at-home mother. He believes that they can come up with their savings, $300, and use the services of bondman, Judge. So that's why I'm asking on this case, which very may well be filed as a burglary of structure, third-degree felony. I'm asking you at this time $3,000 on what could be a third-degree felony, Judge.
All right. I do find probable cause. I will impose a bond of $3,000 and no return to this location, sir. Todd Yennard.
Mr. Yennard?
Do you know his number?
Mr. Yennard, you're before the court. Count 1 is possession of heroin. Count 2 is possession of drug paraphernalia. Counts 3 through 14 are violation of felony probation. Those are all no bond holds. I do find probable cause. The bond on count 1 is $1,000. And you'll be before your division judge tomorrow. I'm going to take a brief recess and I'll be back. down? I said brief recess. Okay.
See if Jean Pierre, I asked him, and it was a misdemeanor cases, and they had assigned two different case numbers because one was I guess a temporary case, and one was assigned a misdemeanor case number, so we had to give them two separate numbers.
Okay.
And this was the original one from yesterday, if you just want to take a look at it.
Oh, okay. They shut us off.
Thank you.
Yeah. That was quick. Whoever's calling.
I'm calling them.
Did you call? I'm sorry.
No, they shut off our recording, so we're waiting for them to go back.
No problem. No problem.
I did. Nobody's answering.
Okay.
I called Pat and Craig.
We only have a few more left. So, Vanderbilt Williams.
Mr. Williams is here at main judge approaching. Come on up, sir.
Mr. Williams, you're before the court for grand theft, and I do find probable cause.
Judge, we're going to be asking the court to consider releasing Mr. Williams on pretrial release. At this time, he's not working, but he's been living here his whole entire life. He lives in Lauderhill with his mother. His mother, from what he tells me, works at a call center, so she's not going to be able to afford to post his bond. So we're asking for pretrial release.
Okay.
And Judge, I do notice that this is a grand theft. Mr. Williams wanted to know as far as the date of incident and the location where the allegations took place.
Looks like it was August 9th of last year at 270 Northwest 47th Avenue. Allegation of tires being stolen off of a 2008 BMW.
Your Honor, I would be objecting to outright release. Noting the allegations, this wasn't taking something from a store that was recovered. The property was never recovered with a value over $1,000. He was arrested last year on a capious failure to appear. 2017, he had a loitering and prowling. 2014, resisting without violence and another loitering and prowling. 2013, 2 more loitering and prowlings and a resisting without violence, 2013.
So, I find probable cause, and your bond will be $1,000, sir. Good luck. Robert Davis.
Mr. Davis, I believe North Broward?
No.
So you see this guy all the time?
It looks like he was a medical reset before, so. Is he still on medical? Anyone?
With someone else.
Medical reset, Judge.
There's a medical reset, okay. And how about Gerald Scarola?
He's here present, Judge at Maine.
Okay.
Good morning, Your Honor.
Good morning, Mr. Scarola. He is before the court on a felony battery. Oh, I do remember this. I do find probable cause. wish to do with Mr. Scarola?
Your Honor, I'll be requesting a $10,000 bond, no victim contact. According to independent witness, Mr. Scarola started the fight. The victim suffered a fractured orbital bone. His history, 2012, he was convicted of violating a pretrial release condition, specifically a no-contact order. 07, 2 counts of burglary of a conveyance, possession of alprazolam, a year and a day state prison as a habitual offender. Those are the most significant priors, Judge.
And we don't know how independent this witness is, Judge. There's a lot, obviously, again, we don't know. This witness actually lives, the woman actually lives in that residence herself, so who knows what was going on as far as their relationships are concerned. But certainly, as I say, there's more here than meets the eye.
And Judge, that's what I wanted to talk to you about. Certainly, as far as from Mrs. Scalarola's point of view, the first person to maybe initiate physical contact was the alleged victim, in which Mr. Scarola suffered injury. As you see, he was medical reset. He was hospitalized. He also suffered a hairline fracture on his nose and also on his jaw. He's 64 years old, Judge. He's weighs 131 pounds. He's 5'11". My understanding of the victim is 48 years old, weighs 210 pounds, and is 5'10". Judge, he's retired. He gets Social Security. He gets approximately $565 per month. So, Judge, I'm going to be asking you for $1,000 and a photo order so we could photograph Mr. Scarola's injuries.
All right. I am going to impose a bond of $2,500. No victim contact. All right. Good luck, sir. Curtis Harris.
Mr. Harris refused to join us, Judge.
All right.
Your Honor, I'd ask that the bond be set at $7,500. It's a change of charge.
Which one?
Mr. Harris, count 1. That's all I have on the...
Oh, it's a change of charge.
Yeah, I believe that's... He was was arrested for burglary of a structure, but the court at his first appearance found PC for burglary of a dwelling, which is what the state ended up filing. Set a $7,500 bond, pretrial release, GPS level 2, no victim contact and no return. So I'd ask that the court set the same condition, bonding conditions.
So it's $7,500 and what?
GPS level 2.
GPS.
And no return, no contact.
All right, as to Mr. Harris, I found probable cause. It's a change of charge, so we'll impose the same conditions as previously stated. Ruben Diaz.
Medical reset.
Your Honor, this is actually a bond surrender.
It is.
You set the bond originally at $3,000. I'd ask.
We did this before? Oh, no, his bond was $3,000.
He bonded out. He was arrested on new charges. His bondsman surrendered his bonds. But because this was, 1 second. It was actually upfiled from burglary structure to burglary dwelling. That being said, I have no objection to the court setting the bond back at what you originally said, and that would be the surrendered bond in this matter.
$3,000. And then Travis Nottage.
Conti, Your Honor. Your Honor, he's in courtroom 7780.
Okay. All right, so Mr. Nottage is in court. Reset. Okay, it was a long one, but we made it to the end.
4